This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Getting a divorce is usually a difficult enough experience on its own. But imagine what it must be like if all the intimate details and the financial arrangements of your marriage are splashed across the headlines for all to see. Today we're going to look at the difficulties involved in trying divorce cases that have received a lot of media attention. Our guests are the Honorable Sherry Heitler, Acting Supreme Court Justice, sitting in a matrimonial part in New York County, and Norman Cheretsky, who has represented many well-known figures in their divorces. Hello, Judge Heitler. Hello, Norman.
Hello.
Judge Heitler, tell me, what happens? I know you've tried many, many cases where you have celebrities in your courtroom and very wealthy people. How do you separate the celebrity status of the people in front of you from the actual job that you have to do?
I don't have to do that, because when they walk through my room, they're litigants, they're people, and I don't think of them as celebrities. I think of them as people who are in trouble, who need my help, and I go to work on the case and see if I can resolve it.
Although these may be people that you've seen on the movie screen on television for years.
Exactly.
And may have been some of your heroes or heroines.
But they still have the same problems.
That everybody else has.
Exactly.
And they all fall into, I'm sure, similar categories.
That's correct.
Norman, tell me some of the people you've represented over the years, the well-known people.
Oh, I represent a lot. Dustin Hoffman's wife, Robert Duvall's wife, Mariah Carey, quite a number of people.
Now, all these celebrities, do they have actually, is there an asset, is there a value to being a celebrity that a judge like Judge Heitler will say, well, you know, that's a valuable asset and that has to be divided up with the spouse?
I think there is, but I hope you're not going to ask me to define it. There is something called celebrity goodwill, which has been recognized in New York, not recognized elsewhere. But I think most of the attempts to define it in some financial way, by the time the judge says, yes, there's celebrity goodwill and we're going to hear expert testimony on it, somehow the testimony usually goes away and the lawyers settle it. And the cases really that have been tried that have attempted to define how would you quantify it, are all over the place. So it's tough.
Judge, give us some secrets. How do you go about settling a case? I assume most matrimonials are settled. Is that correct? Before you give a verdict.
Correct.
Before you come down with the decisions. What's your secret? How do you, and I know you're a great settler, how do you go about settling cases?
She has a hammer right under her.
Oh, a hammer will do it.
Well, I think the first thing that I try to do is I listen. Because if I can understand first what each side is trying to tell me, and then I can get each side to hear what the other side is saying, then I have begun the process. And I don't try to settle everything at one time. If I can find some agreement on both sides, and I think that, you know, Norman has experienced this throughout his entire practice, you can start the ball rolling, because beginning to talk is usually the hardest thing for people to do.
I'm assuming by the time they get to you, they both really want to be divorced. It's just a matter of money.
Well, they don't always both want to be divorced. I'm sure, you know, Norman can give you legions of cases where one side doesn't want to be divorced. They'll contest the grounds.
I think she's right. People get dragged into court. People don't want divorces. People are not ready for divorces.
I'm still in love with my wife, although she has thrown me out of the house and perhaps has established a new lifestyle.
Well, I don't want to give the son of a gun a divorce and let him walk off with the sweetheart who took him away from me. And when he comes to his senses, he's going to realize that she's a bimbo and I'm wonderful. I mean, you have no idea what she hears and I hear.
I assume that's a difficult case to settle in.
Not necessarily. Because many times the person who may not want the divorce is going to be given all the implications if there is no divorce, which, by example, in our state, if you are not divorced, you can't have what we call equitable distribution, which is a division of the property. You can have support, but then the parties cannot divide up the assets. So one has to make a strategic decision if at that point in their life they wish to remain married but not necessarily divide up the assets.
Let's address that. In New York, isn't New York still a fault state?
Well, we have a way of getting divorced in New York State. If there are grounds, people can go in, but you still have to prove fault if you go to trial.
Well, that's what I'm saying. So let's assume the wife wants out of the marriage and the husband has all the assets. It may very well be a ploy or a strategic element on his part to say, no, I'm not ready to give you a divorce.
Well, we just went through that.
Well, tell us about it.
Well, this is the Warner-Leroy case.
And who did you represent in that case?
I represented Mrs. Leroy, and for I think the 5 or 6 years that the case was pending, no word was ever mentioned by either of them that they didn't want a divorce. There were a lot of lawyers, by the way, in that case, and a lot of conferences with a lot of judges, and nobody ever said that the Leroys didn't want a divorce. Then just before the case started, Warner Leroy said, even though he had a few female friends, he said he loved his wife and he didn't want to give a divorce.
And what was your opinion on that? Was it
I
just...
thought he didn't want to give her a divorce legitimately, because if he didn't give her a divorce, then he'd only have to support her, and she wouldn't be entitled to equitable distribution.
half his assets.
So he demanded a jury, hoping that the jury would listen to his story and listen to him talk about it. The words of his lawyer was, he wanted to keep the dream alive.
And what was the result there?
The jury said she's entitled to a divorce.
But the jury doesn't try the financial end.
No, and then after that, the financial case was tried to the judge.
And was there a resolution of that, or is that still pending?
It's still pending. Well, the case is over, but the briefs are being submitted, and the judge will make a decision as to the financial arrangements. But there would not have been any of those financial arrangements had he won the case and had a jury said that she wasn't entitled to a divorce.
Judge, isn't it normally that the judge decides both financial and grounds for divorce?
Well, what I wanted to indicate was that the only thing that a jury may decide in New York State is the issue of grounds. In other words, whether the party should
Adultery,
or should
cruel
should
treatment.
or should not be divorced. But everybody does not demand a jury. If you demand a jury, then you get a jury. But a judge will always try the custody aspect of it and the financial aspect
How
of it.
common is that jury?
Not very common.
In your experience, how many jury trials have you presided over?
About 4 or 5.
In all those years that you sat in the matrimonial part?
Correct.
Okay. Let's get back to that settlement aspect. Is there a formula? Let's assume a couple is out there, a wife is out there, husbands are out there, and they're thinking of divorce. And they got 3 kids in their house. Is there a formula that the court has to follow in support to the children?
Well, there are support guidelines, but if someone makes above a certain amount of money, then it is discretionary with the court. So that when we are deciding what we call pendente lite support, the lawyers put in the briefs. Temporary support. And the one lawyer will put in one brief and the other lawyer will put in another brief on a motion. We have to make a decision as to what the interim support should be, and we have certain guidelines.
Basically, if I'm home and I'm not working, the other spouse is working, I got 2 or 3 kids at home, what can I expect? Do I get 25% of his income, a third of his income? For the children I'm talking about. Is there a formula that I could expect something?
It really depends. Each case is an individual case.
What's the recommended amounts?
It depends upon what the parties are making. It depends what the lifestyle is. You may have 3 children at home and you may be living on $50,000 a year. Someone may come in with a case and they're living on $5 million a year. The judge has to see what the lifestyle is.
So in other words, I'm entitled, let's assume I'm the non-working spouse now, to live the same lifestyle?
Well, that's what the law would like everybody to have, is the same lifestyle, but we have a reality in life that it is not easy, especially when we don't have a great deal of money in a case, to suddenly have 2 apartments and 2 telephones and 2 Con Ed bills.
And the same income.
And the same income.
The reality was that when equitable distribution came along, it was fair, and everybody heralded it and thought it was great, but it really didn't mean very much to most people. Most people in this world have a house, have a car or 2 cars, have a garage, and a lot of debt.
An IRA, maybe?
An IRA, and that's what there is to divide. So a lot of those people say, well, what did equitable distribution mean for me? Because what happened was that for a while, at least, judges were giving support for a lot shorter period of time than they used to. Equitable distribution is really a good...
for the non-working
spouse. But, so equitable distribution is good where there's a lot of money around, and comes into play when there's a lot of money around. And the issue then gets to be, what if these cases are yet to be tried, what if it's $1 billion? And what if, it takes $10 million to produce the same lifestyle that the non-working spouse had before? Do you give the non-working spouse enough money to throw off the $2 million, $4 million, $5 million that she needs, or do you give her $500 million?
Well, unequitable.
Or him. Because I want to just also say one thing, that we are allowed, a judge is allowed in a case to impute income to a non-working spouse, so that in many of the papers that I get on my desk, someone says, well, either the husband or wife is not working, but that person could be working and could be making a certain amount of money, so judge, it's not fair to just base everything on what I'm doing. I want you to impute to my spouse a certain sum of money.
What is equitable distribution? What does it really mean? Do I get half? Do I get 40%? Do I get 45%? What are we talking about?
Boy, I wish I knew the answer to that. It depends on whether I'm representing the husband or the wife. But the answer is, in this state...
That's an honest answer.
The answer is, in this state, I think, so far, there is a tendency in long-term marriages where there have been contributions, real contributions, and children by non-working spouses. I believe that courts are dividing 50-50. But there are going to be cases where that's not fair. And what hasn't happened yet is, seriously, is what happens in a case where there are billions of dollars to be divided by a court. And the issue is, do you just say, well, equity is, I'm going to give $500 million. That hasn't been decided yet.
Judge, let me ask you this. What happens to the person, let's assume it's a second marriage and I have a business, a successful business, I've had it for years, or a practice, and I get married and we're married for 3 years and I bring assets into the relationship and she brings some assets into the relationship. After 3 years, it doesn't work out and we decide to get a divorce. Is my spouse entitled to a portion of my business?
Well, it depends, as Norman said, I suppose, first, who's representing that spouse and what type of argument is going to be put forward. Now, let's say, hypothetically, you had a good business, but let's say...
I had it for 30 years.
Let's say you had it for 30 years and it was a good business, but let's say you married someone who gave you a fabulous idea. You were producing widgets. She said produce wadgets and circulate them throughout the world, and suddenly that business that was a $10 million business is now a $40 million business.
Who has the burden of proving that?
Well, the burden in many instances starts to shift in a case. She comes into court, she's going to say he has X number of dollars, and she's got the burden to show that you have X number of dollars.
Another example, Judge. I'm a businessman, but I got a few stores and I got a few restaurants, and I show income, but you know something? I really make a lot more.
In other words, you're telling me you're the spouse that has that classic tax return where you make $40,000 a year, but you have 4 cars and 3 houses and you take a vacation every 2 months.
That's correct.
What do we do as the court? Well, one of the first things that I will do if I see that type of tax return is that disturbs me. Because first of all, it means that I am not being told a complete truth. So the first thing I'm going to do is I'm going to bring in my own experts to take a look at what is going on.
You're going to
in terms of
report
that.
accountants and appraisers?
Exactly.
Long before she does that, she's going to also tell the husband's lawyer, I think you have a problem here, and you may want to go outside and settle this case.
Well, now the interesting thing also is
That's what I think she's gonna do.
it's not always just the husband's attorney that's being told that, because many times the court is getting tax returns signed by both parties who took those vacations together, know about the 4 cars. And I think it's interesting to note that as judges, we are mandated reporters to the IRS, which means that if we hear something at trial that makes us uncomfortable, we are obligated to
And
report
you heard
that.
it here. We have to take a break now. We'll be right back. This is Lola, and I'm Alan Schnorman, your host. Stay with us. Hello, I'm Alan Schnorman. Most of you know me as the host of Lawline, and for the past 16 years you've been watching me interview some of the most knowledgeable experts in the field of law. By now you understand the importance of choosing the right attorney to represent you. So, with so many personal injury attorneys to choose from, how do you know who to call? At Zalman & Schnorman, between myself and my partner Ben Zalman, we have over 50 years of litigation experience, and I'm proud to say a proven record of satisfied clients. Our goal is to make certain you receive fair and equitable compensation for your injury. So if you've been injured in an accident of any kind, including a construction accident, a motor vehicle accident, a fall-down accident, call us at 1-800-LAWLINE. We'll be happy to speak to you and evaluate your case, and there is no fee. If it is impossible for you to come to our office, we will come to see you. We know that this could be a very difficult time in your life, and we're there to help you. So call us at 1-800-LAWLINE. Hello, I'm Alan Schnorman. You're watching Lawline. We're talking about high-profile divorces. Our guests are Judge Sherry Heitler, Supreme Court, New York County, and Norman Sharetsky, a very well-known matrimonial attorney. Norman, before the break, you had mentioned that you represented Joan London's husband.
Yes.
Can you tell us about that case?
Well, it was sort of an interesting case. Here is a guy who had everything to do with his wife's career. I mean, he was the producer of the show in which she was the absolute novice. He discovered her, he put her on the show, he trained her, he taught her, and then as the years went by, she became the big star that she became, and ultimately wanted a divorce. And so she wanted the divorce, and she, at that point, was the big earner. So the issue was she entitled to receive, first of all, maintenance, which is alimony, and that went to court, and she got a very large award of maintenance.
She was entitled.
He was
entitled to maintenance.
And then ultimately...
Did he stay home? Was he home with the children?
Well, he was either home with the children or home helping her with the program, and certainly home with the children, because one thing that I don't think any was even in dispute, because they had joint custody of these kids, and obviously when she was on the air as much as the time as she was and traveling throughout the country, it was important for somebody to be with the kids, and who was with the kids was him.
And what about equitable distribution?
Well, he certainly asked for equitable distribution. The case was settled.
It was. But in the settlement, if you can tell us, did he receive a part of her celebrity status?
Yes, he did.
The goodwill?
Yes, he did. And I think it's only fair. But, you know, how the details of how you quantify that, as I said before, it was the subject of a lot of dispute, and we ultimately came upon a number.
Judge, do you ever issue in celebrity cases gag orders where you say, hey, listen, I got enough problems here. I don't want you talking to the press?
If I'm in intensive settlements with the lawyers, I suggest to them that they probably should not, but I have not issued gag orders.
Well, I know in some cases. Have you ever had a gag order issued in any case?
No, I never have.
Under what grounds would you issue a gag order on a matrimonial or custody matter?
Well, it's tough. I mean, you know, it's really tough for a judge to do it. And the only way correct me if I'm wrong, Judge, but I think the only time you can do it is if there's some danger to children. That would be about the only time.
I would agree with that.
Custody matters, can those be settled as well?
All the time. All the time. Same techniques. And just the way we call in experts with regard to the money, many times a court will call in experts with regard to the children. We can call in psychiatrists, we can have psychological testing done. Sometimes, unfortunately, we have children who have physical problems. We can call experts in those areas, too.
In a matrimonial case, is there just come a time when you have to wait for that time to come when it's ready to be settled?
Well, that's a very interesting question because many people in the matrimonial bar feel, and you can now correct me if I'm wrong, that sometimes there's a natural life to a case. And of course, as judges, we have certain guidelines that we have to deal with in how we move cases forward. But my experience has been that if the case is already in my courtroom, that I have to start moving it. And sometimes you can move a case by taking 2 steps forward, and you know you're going to have to take a step backward, but you still have to continually bring the parties in, see what's going on, so that ultimately you know you're going to be getting to the end of that case.
Sometimes, you know, the judge and I have had conversations about this before. Sometimes you go to these meetings of judges and they talk about pushing these cases through the calendar, you know, and I say they drag them. There are cases very often that because they have not reached that point in the people's lives where they're really ready to get a divorce, are best left alone.
Well, you mentioned before that you represented Mrs. Warner Leroy, and that case took 6 years to reach its final day, which was trial?
Sure, there were reconciliations, there were changes of lawyers, there were a whole bunch of things. But you know, sometimes your client is just not ready to listen to what you have to say. And the danger of some judges is that they get called by their administrative judge and they're told, you know, what happened to the such and such case? Let's get it tried. And what you have is an unnecessary trial that, if it was given more time, might have settled by itself.
Judge?
I'd like to think I have never had an unnecessary trial. But there's a certain point of truth to what Norman is saying. There is a time, but we have to remember that in some of these matrimonial cases, there's a great switching of lawyers. Sometimes one party has had 5 or 6 lawyers. And I feel if it has reached me, in other words, many cases are started in lawyers' offices, and you should know never hit the court system for 3, 4, and 5 years. But by the time it hits my courtroom, I believe that I have to take an active role in moving it forward.
But better yet, in some of the things that judges, not you, Judge, but a lot of the judges don't realize, there are hundreds and thousands of cases that get processed through lawyers' offices and you never see, period.
Well, that's exactly
Judge,
right.
Because
Let me ask you this. When lawyers come before you, I'm sure after years, that you know the lawyers' personalities. And some lawyers are known to be never settle until court, or just don't settle, and they won't settle in their offices, and bombers is one term that I've heard over the years.
we know who they are.
Their names are written down.
That's right, we have
Now,
those.
how do you handle something of that nature, where you know that settlement may be the best interest for the client, but because the lawyer has injected, or she has injected her personality into the matter?
Well, first of all, I always have the clients in the courtroom. And so I will many times conduct a conference in which I will bring the lawyers in first, and then I will have the clients in. And I make it very clear, and when I say very clear, I make it not only clear to the clients, but I make it clear to the lawyers as to what my position is, as to what's happening right then and there.
You see the lay of the land.
I see, and I let everybody know what's going on, and I lay out the lay of the land, and I tell them the roads that they can walk down. And that's generally my preliminary conference. And if I feel that one lawyer is being, and I'll use the word difficult in a case, I will try very hard to, not to categorize that lawyer as difficult, but to try to get beyond that problem so that I can settle the case.
Norman, my viewers are always interested in money. How expensive is it to get a matrimonial lawyer? I mean, what are we talking about here?
Well, you're talking about retainers that go all the way from, $500 to $100,000.
Well, can someone come to you with $500 and retain you?
No, they can't.
I mean, so in other words,
That's why I
what
said
realistically...
there's a big difference between what various lawyers charge,
Well, let's
either
assume-
by the hour or as a retainer.
I'm the non-working spouse. I really don't have a bank account.
Yeah.
Well, you know, we live a nice lifestyle, but he or she, and I'll say he just for this conversation, he handles all the monies.
Right.
But, you know, I want out of this marriage, and I come to you, and I don't have any money, or I get a couple $1,000s. What can I do?
I give you the names of a lot of good lawyers who'd be glad to handle your case. I would not be one of them.
So you have to get paid up front, otherwise you don't take. And your normal retainer or the normal retainer of attorneys like you, how much would they be?
$25,000.
Oh, my God.
$450 an hour.
$450 every hour.
Yeah.
So certainly to get divorced, and if it's contested, how much would that run?
It could hopefully run $25,000. One of the nice things about hiring a lawyer with experience is that sometimes it doesn't get any more
But normally, if it's
expensive than that.
contested and we're worried about the custody, and are we talking about...
It could be hundreds of thousands of dollars. It could be over $1 million.
So it really is something, at least at your level, something very, very substantial with lots of assets.
That's correct.
I have
But
to
it's complicated. I think the judge will tell you that we don't get paid for nothing.
Well, they don't get paid for nothing, and I should also say that many times I will receive, at the inception of the case, what we call that first pendente lite motion. Temporary support, exactly, where the lawyer will say, Judge, my client may be living in a $30 million mansion, but my client has no money. I am making an application to you right now for legal fees from the client's spouse. And that lawyer will put in his credentials, and he will put in the financial statement, and then I, as the judge, can level the playing field by saying, okay, you don't have access to money, you do. You will pay X number of dollars, hypothetically, to Norman Sharevsky without prejudice to my making a determination later on
And
as to who should pay the fees.
I must say, a tendency on the part of courts now to want to level the playing field.
Absolutely.
Judge, it seems like a contested divorce is so expensive and really way out of the reach of the normal working-class household.
It can become extremely expensive, and that's why we make a great effort at the beginning of these cases to advise the clients to think about the road that they wish to walk down. You know, the lawyer is the conduit, and the lawyer can advise the client as what to do, but ultimately it's the client's decision.
Alan, we get paid now. You know, this. I'll tell you a secret of the trade.
Wait, this is wrapping up.
Here's a fast secret. We get paid mostly for doing absolutely dumb work, arguments over things that should never be argued. We get paid because clients won't do what we tell them to do, and that they misbehave toward each other, and we are forever getting paid to try and get them out of what they should never have gotten in to begin with.
Judge, what would you like to leave with the public?
Try to resolve your differences.
And you heard it here. Norman Sharevsky, thank you for being on Lawline. Judge Sherry Heitler, thank you for appearing on Lawline. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.